It affects the Commonwealth as we are an administrator of jointly funded programs. For MassHealth, which is our Medicaid program, we receive funding from federal government and provide health care coverage to low and moderate income individuals. DOMA makes us, requires by law that we treat individuals differently depending upon whether they are same-sex couples or different-sex couples. In terms of veteran services, the Massachusetts Department of Veterans Services operates cemeteries in Agawam and Winchendon for the burial of Massachusetts veterans and their spouses. We receive money for those purposes in federal grants to construct and improve them. The federal government has said that in this instance we cannot inter in either of those cemeteries the same-sex spouses of military veterans because they are not considered to be spouses under federal law. That seems to us to not make sense and to be unfair. The theories upon which we brought this lawsuit allege that they violate, the DOMA violates the 10th Amendment to the Bill of Rights. It violates our spending clause, and we are seeking a claim of declaratory relief as to Massachusetts and the effect of DOMA. We are specifically seeking a declaration that Section 3 of DOMA is applied to Massachusetts and our federally funding programs is unconstitutional. We are also seeking an injunction that prohibits the federal government and its agencies for enforcing DOMA against the Commonwealth. We believe, based upon 10th Amendment sovereignty issues, that Congress has impermissibly interfered with state sovereignty in violation of the 10th Amendment of the United States Constitution. Briefly, under our system of government, there are, although there are not many left, there are certain powers and authorities that are delegated to the federal government and the others remaining to the states. For over 200 years, the federal government recognized that the authority to create and regulate marital status was a power that belonged exclusively to the states and was an essential aspect of each state's sovereignty. However, as a result of this statute, as of DOMA, the federal government invades that sovereignty, we believe, and is a violation of the Constitution. We also believe that it violates the spending clause, because under the spending clause power, Congress has wide latitude, we know, to impose conditions on states seeking to obtain funding for a variety of programs. We recognize that and we accept that. For example, Congress can require states not to discriminate on the basis of race as a condition for funding. However, one clear limitation on congressional authority in this area is that Congress cannot induce states to violate the constitutional rights of its citizens in order to qualify for funding. Our lawsuit asserts that DOMA is unconstitutional because it now requires us, the Commonwealth of Massachusetts, to disregard the marriages of same-sex couples when implementing federally funded programs. Again, as our Supreme Court said, under our Constitution, it is unconstitutional for Massachusetts to not allow same-sex couples to marry. We believe that we cannot and should not be required to violate the equal protection rights of our citizens in Massachusetts who choose to be married. What this lawsuit does not cover, it is, as I mentioned, limited to the impact of Section 3 and only on the Commonwealth. We do not assert any claims regarding how other states define marriage, nor is this necessarily about the right to marry. We don't assert claims that whether the federal Constitution permits or prevents a state from extending civil marriage license to same-sex couples. What we do seek to do today by filing this lawsuit, however, is to remedy the fundamental unfairness that DOMA causes to Massachusetts and its residents by denying those residents equal treatment under the law. I'm prepared to take questions.